The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning and welcome to council. I would also like to welcome Judge Kate Lynch, who is sitting with the court for this case. Justice Standridge has recused and Judge Lynch is sitting in for her on this matter. Judge Lynch is a district court judge in Wyandotte County, where she has served since August of 2006. Judge Lynch has taken time from her busy docket today to help us with this case. We're very honored to have her join us today, and we want to thank her for her assistance. Council, you should know that Judge Lynch has read the briefs along with the rest of us, and we are all looking forward to your arguments. She will participate in our conference and in all proceedings through the filing of the mandate in this case. I would now ask Mr. Doug Shima, the clerk of the appellate courts, to please call the 11 o'clock case.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Tuesday, May 25th, 2021 consists of one case. Appeal number 122696. State of Kansas through the Secretary of Department for Children and Families and EF versus M.R.B Jr. Douglas County, briefs both sides. The appellee petitioner has reserved 3 minutes rebuttal time. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please enter your appearances?
Madam Chief Justice, may it please the court, Jody Meyer on behalf of appellee EF, present and ready for argument.
May it please the court, Your Honor, respondent appellant M.R.B. appears by and through counsel Shay Downing of Sloan, Eisenbarth, Glassman, McIntyre, and Jarbo, present and ready for argument.
Thank you, counsel. Ms. Meyer, you may begin with your argument.
Thank you, and may it please the court. As a brief summary, this case originated as a paternity case regarding the minor child JF. This case was filed in 2012 when JF was an infant. Between 2012 and 2017, the child lived exclusively with her mother, EF. In February of 2017, the child's father, M.B., filed a motion to modify custody in which he requested that the child live with him in Pennsylvania. That motion was tried in November 2017. Of note, there was no guardian ad litem appointed for the child at that time. After the conclusion of the trial in November of 2017, the trial court denied father's motion. For a variety of reasons, the trial court's orders from that hearing were not journalized until October 21st of 2018. In November of 2018, the father, M.B., filed an emergency motion to set aside the journal entry for parenting plan, alleging that KSA 60-260B6 allows the trial court to vacate a judgment based on any reason justifying relief from judgment. M.B. argued that new information had come to light that the court did not have at the time of trial in November 2017 that warranted setting aside the trial court's orders and reopening the case. The trial court did not grant the motion immediately, but did appoint a guardian ad litem to do an independent investigation. The trial court ultimately held a trial on that motion on April 4th of 2019, at which time both parties were represented by counsel and the guardian ad litem also appeared for the trial in the case. The trial court denied M.B.'s motion and kept custody of the child with EF. M.B. timely appealed the district court's decision. On October 16th of 2020, the Court of Appeals issued a memorandum decision in which the court reversed the decision of the trial court and ordered that primary residential custody of JF be awarded to her father and remanded the matter to the trial court to make all other orders not inconsistent with that decision. EF petition for review. In our petition for review, appellee has presented two issues: whether or not the Court of Appeals erred in finding that the trial court ignored the guardian ad litem recommendations, and whether the Court of Appeals erred by inappropriately reweighing the evidence in this case. I will start with my first issue regarding the guardian ad litem. Supreme Court Rule 110A sets forth the standards for a guardian ad litem. A guardian ad litem must, among other things, conduct an independent investigation, must determine the best interest of the child, represent the child in court. Regarding court proceedings, a guardian ad litem must file appropriate pleadings, represent the best interest of the child, and present all relevant facts, including the child's position, submit the results of the independent investigation, and vigorously advocate for the child's best interest by calling, examining, cross-examining witnesses, submitting and responding to other evidence, and making arguments based on the evidence. In this instant case, the guardian ad litem did not call any witnesses nor present any evidence. The trial consisted of the testimony of 6 witnesses: the mother, the father, their significant others, the child's therapist, and the child's maternal grandmother. The guardian ad litem did not bother to cross-examine M.B, the father of the child, or his current wife. The guardian ad litem's closing argument was very brief. The guardian ad litem did file I guess you could call it a report of a recommendation prior to trial. However, the guardian ad litem merely stated with whom she spoke and her recommendations. She provided no analysis on her written document filed with the court for the recommendations that she had made. The Court of Appeals stated that the trial court ignored the guardian ad litem's recommendations, that the written findings did not acknowledge the guardian ad litem's recommendation, and did not acknowledge the guardian ad litem's role in the case. I would argue that the guardian ad litem in this case acted as an attorney for the child, participated in the court proceeding, cross-examined some of the witnesses, and then made a short argument at the end in which she stated her position. I don't know that the trial court should be required to make findings after the court hears the recommendations of the guardian ad litem as to why the court's not adopting that. In this particular case, considering that the guardian ad litem presented no evidence and really provided little to no support for her recommendations and either her report or her closing arguments, it's not unreasonable for the district court to weigh the evidence on its own and not follow the guardian ad litem's recommendations. It begs the question of whether a trial court needs to specifically acknowledge the recommendations when a guardian ad litem has had a fully participatory role in the trial. And her closing argument at best sums up her opinion of the evidence heard at trial. And I would ask that the court hold that that is not necessary and that the Court of Appeals placed too much weight on the fact that the trial court did not explain why it wasn't following the guardian ad litem's recommendations.
Counsel,
Yes.
isn't that really the nub of the problem here, in that you're claiming that the Court of Appeals made fact findings that were not appropriate for an appellate court?
Yes.
Can you tell us what significance, if any, the original domestic relations affidavit filed by the mother in 2012 listing her assets and the child support worksheets, the domestic relations affidavits would have had during the hearings and on the court's decisions?
Well, Judge, the previous information that the court had showed that the mother had very little money and very little income. There were, what's truthfully not on the record is what all happened in the interim between the time of the first trial and the time of the second trial, which is several hearings that had to do with whether father should have adjustments for travel costs, how much mother could contribute to that, and what her income was. There were several hearings had to do with the jobs that she had, the income that she did. So my assertion is that the trial court had much more before it as to mother's ability to pay and mother's financial circumstances than what the Court of Appeals gave it credit for.
Were those documents fair game, though, for her to consider as part of the record in making her decision?
Your Honor, I would argue that they were. I mean, they're already a part of the court record. The court can take judicial notice of the filings in the case. I might add that it's important to realize that this case was entirely tried before. The judge made findings before. And to some extent, the Court of Appeals went back and relitigated the issues from the first trial. I mean, the first trial was not appealed to the Court of Appeals, and the findings that the trial court made in that first trial were not disputed. And strangely, at the second trial, a lot of those things kind of came up again in terms of context of the past, but the trial court had already made prior decisions from that first trial. And I think that the trial court has the ability to consider all of those things when hearing a second trial, particularly considering the fact that this was styled as a motion to set aside pursuant to 60-260.
Didn't the court in fact do that, reopen the record and consider more evidence?
Well, to be quite frank, I don't know that it's very clear as to how the court considered it when the trial took place. I mean, clearly the court considered additional evidence in some capacity and still denied father's motion.
Am I recalling correctly that the order that's under appeal right now was rendered from the bench or in writing? I'm struggling with our electronic record right now.
It's sure, Judge. The decisions in the case were all rendered from the bench and then later memorialized by the attorneys. Well, I shouldn't say that. I'm sorry. The judge actually did findings of fact and conclusions of law from the second trial. The first trial, it was memorialized by the attorneys in the case.
But the judge signed the journal entry for parenting plan from the 2017 trial.
Yes.
On October 21st of 2018 and filed the order.
Correct.
And then almost immediately, father filed a motion to set aside pursuant to 60-260 to reopen the record. Correct?
That's correct, Your Honor. And I think part of the issue was that father had a different attorney during that period of time up until he filed that motion. And what happened is that attorney withdrew from the case, and then he had a new attorney enter the case, and it was the new attorney that filed the motion. So I really can't speak to the delay and why he filed what he did, other than I can state that there was a change in counsel.
But then the court filed the second journal entry, which incorporated some of the proposed findings and conclusions made by father during the second hearing.
Correct.
So are those two journal entries then to be considered together?
Well, that's a good question. I think that I looked at it as two separate journal entries. I considered it to be, and I think that the court did as well, to be two separate issues. However, I could see where an argument can be made that it's, I guess, a continuous finding, or in addition to the previous findings.
Well, she didn't address any of the financial issues in the second order. So how else would you construe that?
I don't think that she specifically, I guess based on the transcripts, she had made findings to that, I guess made findings about the mother situation. And I suppose you could argue that it was based on previous testimony and things filed in the court file from the first hearing, yes. And I see that I'm out of time. Does the court have any further questions?
I'm sorry, we were going to say the same thing. Are there any other questions? All right, thank you, Ms. Meyer. Ms. Downing?
Thank you, Chief Justice Luckert. May it please the court, I have certainly drafted some written responses, but I wanted to first clarify one of the answers that was given in response to Justice Files' question. The court issued a decision in April, April 11, 2019 from the bench. Thereafter, Mr. M.R.B's counsel filed a request for findings of fact and conclusions of law, indicating that it was her belief that the court's decision was not supported by the evidence. Thereafter, the court issued a memorandum decision, but her initial rulings were directed from the bench on April the 11th.
And
of 2019.
the memorandum decision is the January 24, 2020 order.
Yes, Justice Files, that's correct. And as it relates to another piece of information, the parties had that trial in 2017. However, it took over a year to get that memorialized by court order. And a review of the court file shows that there were lots of motions that were filed by the parties because it was alleged that mother was refusing to abide by the order because it had not been journalized. And so there are motions back and forth about what needed to happen. And then as Ms. Meyer nor myself were participants at that time, it took over a year to have that memorialized by journal entry. And in the interim, the court ordered neutral parties to become involved, such as the therapist. The father in this case also requested the appointment of a guardian ad litem, and that neutral party was further directed by the court to investigate. It's interesting.
And there was,
let me just go ahead and ask, is the determination by the district court that this child should have a relationship with both parents an abuse of discretion?
No.
And so is the determination by the court that the mom would not be able to support a long distance parenting arrangement while a long distance relationship already was working with both parents the way it was that an abuse of discretion?
In this case, yes.
Why?
Because the court had no basis to find that. Even so far as she determined what mom's net income was, that was not supported by the evidence that mom presented at trial. In addition, if you consider the findings that she made about father, insofar as going to say that his wife was supporting him throughout this process, that he was able to stay home and not work during the time that he was obtaining a degree, ignored the court's record before it. Ms. Meyer discussed the fact that there had been multiple domestic relations affidavits and other filings related to child support. All of those indicated with pay stubs that the father in this case had maintained full-time employment while he was in school, that after he ended his military service, he had always maintained a job, and that he was providing support for the minor child. There was no evidence or testimony before the court, especially not admitted at this hearing, which identified that father had somehow been reliant upon his current spouse at that time to provide support. Nor was there any, I'm sorry.
Let's assume that's a mistake. It would be harmless in this instance because the court ordered for the district court ordered that the relationship where the father was financing the long distance relationship would continue. So even if the district court made some mistakes in the father's financial situation, she didn't use that as a justification to move the responsibility over to mother. So I mean, so it might be a mistake, but it doesn't have any effect here, right?
Justice Files, I would respectfully disagree in that she went so far as to say not only could father afford to do other things, that by contrast, mother could not. And in making that decision, she referenced both of their financial pictures without having any support for that decision. Mother's testimony at the trial was that her income had increased. Yes,
Counsel,
Justice.
can I stop you there? Mother filed her domestic relations affidavit showing that she had no assets in 2012. And
Correct.
there was not anything filed by father to indicate that situation had changed with regard to her assets. Can that be considered by the court?
I would argue not, because in the interim, what the court did not address was the fact that initially this case was filed by the secretary, and that the secretary services terminated because mother was no longer eligible. So if you're going to assume that the court was looking at that 2012 file and all the filings in between in order to justify that decision, then that means that she must have disregarded all of the findings in the meantime. She must have also disregarded mother's statements at trial about what her current income was in contrast to what she had in 2012.
Well, but the incomes were set forth in father's child support worksheet and proposed child support order and his domestic relations affidavits in 2018, indicating that his income was only $31,500 and hers was approximately minimum wage. Isn't that the purpose of that, for the court to consider that when making child support decisions and financial decisions?
I agree that that's the purpose of the domestic relations affidavit. However, from father's standpoint, all he can affirm or swear to is what he knows. And mother testified that her income was not a minimum wage income, that she had obtained different employment and was earning far more than minimum wage at the time that the court was making this decision in the hearing in 2019.
But that was a job she had only just gotten, correct? And she hadn't even started it yet, right?
Your Honor, I would certainly reference the court record on the actual dates, but my understanding is that while she had just started that job, she already had indications that she would have additional work hours, et cetera, during the time period that tax season was going to be upon them. And further, the court was not making orders about her past income in reference to past expenses. The court, in fact, was looking to future expenses when making these decisions. So it would be asinine to determine that the court would have to look at her 2012 income for determining what mom could afford in 2018, 2019, and beyond when she has additional information.
Not for her income, but for her assets, it would still be relevant until it's rebutted, correct?
I agree. But the other information on mom's assets were that while she did not provide an updated information sheet about what exactly she had ascertained in terms of assets, she did indicate that her living expenses were minimized by the fact that she was residing with her boyfriend, that she did not have some of the same expenses that most of us who have rental or living obligations have. And so I think that was also important for the court to consider when finding that mom could not afford to make travel to see this child in Pennsylvania. And I do believe that it is further appropriate, as indicated in the briefs to the court, that the court had a different way of addressing that. She could have had an offset in child support. She could have directed that the parties share that expense. She could have directed that father continue to pay that expense. There were a multitude of different ways to address it. And as indicated in the brief and cited in the appellate court's decision, it was an issue that the court created. It was this dual decision that there were only two options appropriate to the case, and the court created that. That is not clear from the record. There was clearly other options that were available to the court. And in light of the other information, that determination seems completely arbitrary.
You would agree
if you
that you would agree that the court would not be able to order the stepmother to pay anything.
I agree. However, what the court seemed to find is that because there were other incomes or other options for father to meet his financial obligations, that overall, based on his financial condition, he could afford to pay the expenses. And certainly that was supported. He had been paying the expenses to travel to Kansas in order to have exercise parenting time with his child. So that was an option available to her. If the court were to review the oral decision from judge in April of 2019, I think that this contrast is even more clear. The criticisms of dad's behavior are that he was following the court's orders. For instance, she criticized him for contacting law enforcement to do a welfare check, indicating that he should have called mom or texted her. And yet in this next paragraph, she says that he is nitpicking and calling mom too often and questioning her too often. And then you go to the second part of her criticism about dad, which was that his demand for FaceTime calls every day was beyond reason. And I find specific issue with that because that was part of the parenting plan that the court had ordered and directed. That was written specifically in the order that he would contact her every day. It was also testified to that she had FaceTime calls daily when she was at dad's house in Pennsylvania. And the therapist suggested that even if the minor child did not wish to talk, it was important for dad to continue to reach out to the minor child as directed by the court when you have a parent who lives 1,000 miles away. In contrast, yes, Justice Rosen.
Let's assume that there are some deficiencies in the findings of fact and conclusions of law that the district court signed. Let's just assume that. Why does the Court of Appeals get to pick a winner instead of just remanding this case back to do a better job of justifying its findings? Maybe coming up with a different answer, but in the end, why does the Court of Appeals get to pick a winner?
Justice Biles, I would identify that I am aware of multiple cases in which the evidence is so overwhelming, as was the case here, that no reasonable fact finder could find what the court found and issue the decision that it rendered. And in essence, that was the Court of Appeals determination, that the court's decision was an abuse of its discretion, was completely arbitrary, and did not take into consideration the evidence before it. So to send it back, if that was the testimony that was found in the finding that was made by the Court of Appeals, there is no other answer but the one that the Court of Appeals ordered and remanded the case back to be addressed with.
But counsel
Ms.
wasn't
Downing,
there. Go ahead.
Oh, I'm sorry. There aren't any findings made by the district court to support the Court of Appeals decision to pick a winner, right? The Court of Appeals is making its own findings, is it not, to reach that conclusion?
I believe that the Court of Appeals is finding that the court's decision and ultimately the district court's decision on what it found were not supported by the evidence and sending it back. If you just consider that on its face, that means that if the district court's decision was not supported by its findings, the only other option then would be to order and direct that this case be remanded with findings that were supported by the evidence. So if you were to eliminate the district court statements at the end about why she was not ordering that the residency of this minor child change and just focus on what she found, then the only outcome which was appropriate would be that this minor child go reside with her father.
Well,
So in
counsel
other
wasn't-
words, the findings that were supported by substantial competent evidence support a decision opposite from the district court. That's your argument?
Yes, my argument is the findings that were supported by substantial evidence and compelling evidence only lead to one conclusion, and that is that the minor child should reside with her father in Pennsylvania.
Didn't the court name an independent person to do a custody evaluation and recommendation?
The court actually identified initially Miss Lynn is what I believe you're referring to in 2017. And what I would announce is, or what I would argue is that the situation in 2017 was much different than what we had by the time we're back before the court in 2019. Part of that is because of the lack of information provided by mother that was found out through subsequent investigation by the neutral parties that the court appointed to do that investigation. So all in all, you had a total of 3 neutral parties, initially Miss Lynn, and then after that, you have the guardian ad litem and the child's therapist.
But the allegations that were made in the motion to change parenting time would have been considered by that neutral party. And she actually recommended that mother retain residency, correct?
To some degree, yes. However, the issues that came up with the mental health diagnoses for the minor child came subsequent to that investigation. The continued moves came up after that investigation. The initial custody evaluation had more to do with the fact that we had a father who was getting out of active military service and was going to be available to be more of an involved parent than the issue of residency, which came up later. Father had not even requested a modification of residency in the 2017 order. That's not what the issue was then. The issue was one of developing a parenting plan that was appropriate for this child. There was not a request for residency modification until much later in that, when mom started having these frequent moves based on whoever she was in a romantic relationship with, and then
Well,
based on allegations the child made.
Well, counsel, with due respect, his February 7, 2017 motion is entitled Motion to Modify Custody.
Agreed.
For many reasons that would have been brought to the attention of the person doing the custody evaluation and recommendation.
Your Honor, Justice Wilson, I do see that I'm out of time. If I may answer your question, if that's
Yes,
okay,
please.
that's appropriate.
Yes, please proceed.
I do note that, but one of the issues that came up almost immediately were reports made by the child about, and it gets titled abuse, and I believe that the arguments get lost on whether or not it's abusive or not abusive in discipline. But the fact remains that the court had ordered that that sort of discipline not be used, and it was being used. The court ordered further investigation to determine what if any of the other court's orders were not being were not being followed, and ultimately the issues that were addressed by the initial custody evaluator were further addressed by people who were authorized and entitled to do a more in-depth discussion and investigation, which is what the court heard later.
Let me just ask you something, Ms. Downing, and it goes along with what Justice Biles was asking, and I was thinking about this throughout the argument. Our standard of review is to review the factual underpinnings for substantial competent evidence, which has been done by the Court of Appeals and now maybe by us. But it's the end result here that troubles me, and that is that we're making a custody determination, and now there will have been 10 appellate court judges look at this without ever having seen the parties, been able to assess who they are, what they are, all the things that happen at the trial court level. And to me, are you troubled by that at all, that we're sitting here making a huge determination in this child's life, moving from Kansas to Pennsylvania, without ever having seen or assessed the witnesses? And again, it gets back to, what do we do here? Is that what we do? We're going to make a custody determination at this level. I've been involved in those decisions at the district court, and they're very hard to make, very difficult and very challenging. And I'm just wondering, why are we making that determination here?
Your Honor, I do understand and agree with you that this is a substantial decision that's going to impact all of these parties' lives. However, the purpose of having a review court is when the district court gets it wrong. And when the district court gets it wrong by not following the evidence that's in front of it, there has to be a way to have that decision reviewed. It is not taken lightly that the district court found that this child should stay with her mother, nor is it taken lightly, even by the guardian ad litem in this case, the recommendation was even being made to modify residency. But if we start determining whether or not the Court of Appeals is authorized to make the decisions that it makes, or this court is authorized to make its decisions because of the impact that it has on other people, I think we end up with a system that doesn't work. There's a reason we have this review process, and that's for situations like this, when the court ignores all of the information in front of it and makes a decision that's not supported. And we have to be able to have a system that has that reviewed. And if the end result is one that has drastic changes, as it clearly does in this case, that's the end result.
Are there further questions of Ms. Downing? Anything you would like to say in closing, Ms. Downing?
Your Honor, the only other thing I would like to say in closing briefly is that if the court were to look at the decision, issued by the court orally in April of 2019. The court criticizes mom for her continued failures to abide by the written orders of this court. And criticisms of dad are because he followed the court's orders. I believe that that is clear indication that the decision she made was not based on the evidence in front of her, and that it was not supported by the compelling evidence that it needed to be supported by. And I'm asking that you find that the Court of Appeals got it correct and that we leave it there. Thank you for your time.
Thank you. Ms. Meyer, you reserve 3 minutes. You are still muted.
Sorry about that. Thank you. It was a very good question asked to Ms. Downey earlier about why does the Court of Appeals get to pick a winner? And quite frankly, it's what it did in this case. I think there are several examples of the Court of Appeals reweighing the evidence based on the comments in the decision. For example, the mother had testified that the child was emotionally stable with no behavior problems except when she returned for father. The Court of Appeals noted that the mother points to her own testimony as evidence supporting she had adjusted to her own home. By doing so, the Court of Appeals seems to suggest that mother's own testimony is not sufficient or as substantial as that of the therapist in the case. The Court of Appeals had found that mother had offered no expert testimony to dispute the therapist's diagnosis, which seems to suggest that mother's testimony on its own or those of her witnesses was not weighty enough. And that, I think, is what is impermissible about the Court of Appeals decision. Another example is that the Court of Appeals seemed to nitpick about a comment that mother made that the child had had an eventful life. And mother testified what she meant by that, and that the child had a healthy life, that it was full and not boring. And the insinuation by the Court of Appeals was that they did not believe the mother's explanation of what she meant by eventful. I think taking together that and the comments regarding the guardian ad litem is that there's plenty of evidence the Court of Appeals is substituting its judgment for that of the trial court. It went into depth about the testimony of the therapist versus the testimony of the parents. In fact, in the memorandum decision, it states that the court heavily referenced the testimony of the parents, but not the testimony of the child's therapist without explanation. They seem to be, I guess, completely unpersuaded by the fact that the trial court determined that the weight of the parents' testimony was more of the therapist. And again, those are the impermissible things when a Court of Appeals reviews it, that suggests that they're not reviewing it to determine whether there's a proper evidentiary basis, but are reweighing the evidence in this case. The trial court had a full trial previously where there was an independent person who provided an evaluation, provided a recommendation that the child reside with mother. And quite frankly, the only difference between now and 2019 was that there was a guardian ad litem appointed in the interim that had to do with whether or not the child was being spanked or not. That ended up turning into something completely different from which it was originally designed. But the court had all the information from the previous trial and everything that happened in the interim with the time it made its decision. So for that reason, I'm asking the court to reverse the decision of the Court of Appeals and affirm the district court's decision. If there are no further questions, I will conclude.
Doesn't appear there are any further questions. So thank you to both counsel for your arguments today. The court will take this matter under advisement. Court is now in recess until 1:30 this afternoon.